Mr. Roberts, you have the floor. Good afternoon.
Good afternoon, Your Honors. Jim Roberts on behalf of the appellate. I would reserve 2.5 minutes, please.
2.5? Okay.
And
Can
I
we round it up
apologize
to
in
3?
advance. I have a little bit of a head cold.
Why don't we round it up to 3 for the benefit of the computer? Okay, thank you. Sorry, you have a head cold.
Good afternoon, Your Honors. This is a very serious case. I'd like to think it's the most serious case you have on the docket today because we're interpreting the Open Meetings Act and the Metro Code that also allows for open meetings. Both are good government statutes designed to promote confidence and integrity in our government, and these are very critical. And I would submit to you that what has happened in this case is a tragedy to all the citizens. But I'd ask this court to consider about 2 facts before we get really started. And one is the fact is that there is actually no proof in this record that at any time the Metropolitan Department of Law was representing the Election Commission. And many times in the briefs, especially from the appellees, they talk about these executive sessions, and I would submit to you that there's not a single shred of proof to say that they were acting as the attorneys for the Election Commission. In fact, the complaint itself repeatedly states that Metro Legal, on behalf of the Metropolitan government, was acting adverse to the Election Commission every time they met, every time they talked. Everything that they did was adverse to the commission. And so therefore, when you hear the word executive session come out of opposing counsel's mouth, he's trying to jump to the end without establishing that there was actually an executive session. They rely, and part of their arguments, is on a hearsay article from the Tennessean newspaper. And as you know from the facts, Tennessean reporter called me on September 17th to ask my opinion about a secret meeting that was being held the next day between the Metro Legal and the Election Commission, a state agency. And I was quoted in that article, incorrectly I might submit, and I would submit that article as pure hearsay to begin with. But interesting in that article, assuming from the moment the Tennessean reporter got something right, the very first line of that article states that the Election Commission is going to meet or going to hear from the city's legal team. Not its own legal team, not its own lawyers, but the legal team from a separate third-party entity. And that's what Metro would be to the Election Commission. And you ask why they were meeting? Well, actually, the article's second paragraph says, really simply, they were meeting so that the Metro government could make its case while the petition should not be placed on the ballot. That is not the Election Commission meeting with its lawyers. That is the Election Commission meeting with someone else's lawyers to be threatened and intimidated and to hear discussion about what the Election Commission could do. And that is why we say that this does not fall under the rubric of the executive session, because that's not what this was for. Even Chairman Duane, who is the chairman of the commission, stated at that meeting, and I had a meeting on the 17th, the 18th, the 22nd, and the 25th. At that 25th public meeting, there was much discussion about this ballot initiative. All of that came after the secret. But in that meeting, Chairman Duane, and we quote him in our reply brief, he said something very interesting. He's talking about filing a lawsuit, because the Election Commission wasn't sure what to do. And he was talking about filing a lawsuit, and he says in public meeting that he's uncertain if Metro Legal will represent them in this lawsuit that they might file. And he said that Metro might even be suing them. I submit to your honors that there was no discussion at that public meeting on the 25th of September about Metro Legal or Metro government suing anybody.
Counsel, let's assume you're right about the meetings, the 2 secret meetings here. Why doesn't the meeting on the 25th cure any violation in this case? What is it that was supposed to be said? I mean, the cure standard seems to be tied to sort of a full discussion or an open discussion of the relevant issues, the matters. What is it that was supposed to be talked about on the 25th that's missing? What's our missing discussion that should have been there to be an effective cure?
Certainly, Your Honor, they could have cured an open meetings violation at that meeting. And there's plenty of case law that shows where boards and commissions have done that. What you don't see when you read the transcripts from that meeting, and it's not real long, there is not one single reference to the prior 2 meetings. Nothing said about what happened on the 18th, nothing that happened on the 22nd. Every single quote pulled out by the appellees talks
Can you
about
be a little more
advice given
specific
at
there?
that meeting.
What is it? Reading your brief at times, I get the sense, and maybe this is wrong, maybe I have a misunderstanding of it and you're going to set me right here, that what the failure to cure is that they didn't talk about whatever legal advice they may have received. Now, you could be right, that they weren't acting as their attorneys, that it really wasn't proper legal advice, but at times when I'm reading your brief, I get the sense that, well, they should have disclosed the legal advice that they were receiving at those two secret meetings. That's not required, though, to cure, is it?
But we know that. The only thing we know, possibly, about what happened on the 18th and the 22nd was Chairman Duane saying that Metro might sue us. Where did that idea come from? It couldn't have come from the August 27th meeting of the Election Commission, because there was no mention there of anything. Petitions hadn't been filed at that point. Where did the idea that they were going to be sued by the Metropolitan Government come from? And I would say to you that came from the 25th. There was no discussion. If you read the transcripts of the meeting, I know they say it over and over, but there is nothing in there at all discussing what happened to those prior two secret meetings. And that's the danger here. It's if this court says this is okay, then the Metropolitan Government will be able to meet with state agencies anytime it wants.
Did they have to
and
talk about
nobody know about it?
Counsel, do they have to talk about the meetings, or is it enough to discuss the issues that were raised in terms of the the ballot initiative, the process, what they're going to do? The last of these sort of sequence of meetings is open, and there's a discussion there of the matter. Did they have to talk about, well, this is what we all said, but sort of a minute-by-minute recount of that discussion, or is it enough to sort of have a full discussion at the third meeting here following the two secret meetings?
We are also included, though, when boards and commissions, the case law supports it, when they do meet secretly or in emergency or for some reason that's not properly publicly noticed, then those boards and commissions can cure it by making specific reference and justifying the secret meeting. What we have here is no justification, and that's sort of the problem with this, because the Election Commission met with a third party. Just because it happened to be Metro Legal is significant, but what if it had been someone else, someone in an industry, someone in a neighborhood? What if there had been another convening of interested parties without any public knowledge disclosure? We're lucky that the reporter found out about it. If the reporter hadn't called me, we would have never known. Or had an article, I guess. That's the problem. A
justiciability-related question I want to ask you here, which is the Election Commission raises the argument that this case is not justiciable because it's a moot. They also may raise a standing argument, but the mootness one is what I have a question about. I went back through your reply brief, and I didn't see a response to the mootness issue. I know you flagged it in terms of issues presented. It's Roman numeral 4, mootness. And as I'm reading through your brief, I see issue 3, and then on page 26 we seem to jump to issue 5, and I didn't see a response in your reply brief on the mootness argument. I may have missed it. I don't know if you want to address that, though.
So our response, you mean?
Yes, in your brief I didn't see a response to the Election Commission. The Election Commission says your case is moot, and I didn't see a response to that argument in your reply brief.
Well, we tried to argue, John, and since it's because it's an Open Meetings Act issue, it's much like the standing issue. You can't have a mootness applied to a violation of the Open Meetings Act because it would always be moot.
Did you make a mootness? Did you respond to mootness anywhere in your brief?
I thought we did, John. Quite honestly,
okay. I'll look back through.
I would not have not done it. I guess. And that is the simple nature of the Open Meetings Act. You're never going to have damages. It's about holding government accountable to a standard of openness and transparency. I understand their argument that say, we cured it. And certainly they made an effort to present some evidence at that September 25th meeting. But at no point, and all I can do is ask you to read the transcripts, at no point did they take any of the steps that case law has recognized to cure those violations. Now, we also, of course, this was a Rule 12 motion to dismiss and judgment on the pleadings. And if we look back at the complaint, we're not really at the trial stage yet, although it was sort of treated that way. From a Rule 12 standpoint, we have asserted that Metro was not the council. We have asserted that Metro Legal came in there adverse to the Election Commission. We've asserted that third parties were present that disrupted any sort of attorney-client.
As part of your
Why
claim,
were those meetings publicly noticed?
As part of your claim, make sure I've got this right, you're also asserting, in addition to the fact that counsel was there, that there was a conversation that began at each of those secret meetings regarding what action should be taken, sort of assuming it's legal advice for purpose of argument. Your complaint still asserts that there was a conversation that began that was improper outside of any legal advice, and I know you're disputing that it's legal advice, but that there was a conversation that began at each of those meetings as to, well, what do we do about that? Now that we've got this information, let's go ahead and start a conversation about what we're going to do. That's part of your claim, right?
Absolutely, and I would assert that it was probably a little stronger than that, and that they began formulating a policy, they began pressuring the election commission, threatening the election commission, that all of those things that started, and those discussions with those commissioners was improper. I'm sure they didn't mean to violate the Open Meetings Act, but once they started discussing, and once Metro Legal threatened to sue them if they went forward and put this on the ballot, you're in the realm of what needs to be discussed publicly. What we're trying to do is prevent an unending, unlimited number of secret meetings like this that we accidentally discovered. That is not contrary to the Open Meetings Act, and I would submit, Your Honors, that the narrow exceptions carved out of the Open Meetings Act based on the Tennessee Constitution, right? The legislature said everything's going to be public unless it's constituted. That has been interpreted to say that the advice given, not the existence of the meetings, not the people participating, but the advice given is what is protected. And I respect that. As a lawyer, I respect that. But that's what's to be kept secret. But it's not secret in the sense that no one ever knows they got advice. I would submit to you that the Open Meetings Act requires them to have a meeting, go into executive session, receive that privileged advice, come back out and discuss it, and then we move forward with good government. What should be prohibited, and I'm asking this court to prohibit, is a secret meeting that no one knows about, where the metropolitan government comes in and advances its own interests adverse to a separate election commission.
Well, what can we do to remedy the situation?
The remedy of this, Your Honor, it's all Open Meetings Act is, I don't know if we can set aside what they did, but the Open Meetings Act allows the court to maintain jurisdiction.
But what did they do?
We don't want to join them from doing this again.
But what did they do that we can say they can't go forward with?
Have meetings that aren't publicly acknowledged.
Well, the law already says that.
Well, I
So we
submit Your
can
Honor,
say,
said
we
that they
can put
just,
down an order that says the metropolitan government and the Department of Law shall follow the law going forward.
well, I submit Your Honor, the
I mean,
law does say.
seriously, I'm not being flippant, but what can this court do?
This court, Your Honor, if I can
remedy
finish
the
the
situation.
answer, what this court, I'm asking this court to do is, as a matter of policy rule, that if the metropolitan government or any legal entity wants to meet with a state agency or a board or commission, that it do so publicly, then go into an executive session, receive their advice, and come out and discuss it. And to not have secret meetings that the public doesn't know about, have discussions, or even the hint of discussions that the public doesn't know about, but to do this all in an above-board fashion. I mean, that's not asking a lot, and I think the Open Meetings Act requires that.
But what I hear you saying, and correct me if I'm wrong, that you want us to write an opinion that says the metropolitan government shall follow the law going forward.
Well, I would, no government could do this. I mean, I think the application is broader, but that the Open Meetings Act requires that there be a meeting, that it go into executive session, and then come back and discuss it.
I agree.
That's all I'm asking. Thank you.
Okay, thank you, sir. Mr. Sauer? Good afternoon.
Good afternoon. Edmund Sauer of the Nashville Bar on behalf of the Election Commission. The easiest and narrowest ground to resolve this appeal is the Cure Doctrine that Judge Usman referenced before. Even assuming this were a justiciable controversy, standing and mootness arguments set aside for the moment, even if the Election Commission had in fact violated the Open Meetings Act, which we of course dispute, but even if they had, as a matter of law, the Commission cured any conceivable violation by having a full 2.5-hour meeting in the public where the Commission debated among themselves, heard from 5 different members of the citizenry, heard from plaintiff's counsel himself, and had a full airing of the legal and policy issues at issue here.
Do you have to address, as part of curing here, and one of the objections that's being raised by opposing counsel is there's not an agenda, there's not a disclosure, these were secret meetings that were occurring. And do you have to have some sort of disclosure that the act has occurred as part of curing? Do you have to have a reference to there were these meetings, we're now having this meeting? Does there have to be some sort of disclosure of the violation?
No, Your Honor. This body of law is developed quite significantly, and there's no hint of that in the case law. The purpose of the act is to ensure that public policy is formulated in the public so the public can see what's going on. And the case law has consistently held that even if there had been private meetings where opinions had been formed or views had been tainted, if the public is given the opportunity to see what courts have called a free and open exchange of ideas, that in and of itself, as a matter of law, cures any conceivable defect from having the private meeting in the first place. And what we have here is a public record attached to the answer, a transcript of that 2.5-hour public meeting where the commissioners debated among themselves how to respond to the petition. Citizens were given an opportunity, including plaintiff's counsel himself, to express their views. Some proposals passed, some didn't, but there can be no question that there was a free and open exchange of ideas. Now, there might be an issue if there were some indication that there had been just a rubber stamping of a decision previously made, but we have a transcript of the 2.5-hour meeting itself that disproves any such allegation. And so under the cases, Kingston Springs in particular, then Judge Koch's opinion, that addressed the same argument that Mr. Roberts is advancing, that somehow the board members or the commission members were primed to think a certain way, that their opinions had been crystallized going in. The plaintiff made the argument in Kingston Springs and still held as a matter of law the fact that in that case it was the city commission, the fact that the city commission held a public hearing on an annexation ordinance after these alleged private meetings, that was enough to cure it as a matter of law. And so Chancellor Lyle, this was an alternative holding of her opinion, and again, that's the narrowest ground on which to affirm.
Counsel, I want to redirect you a little bit towards justiciability for a minute here. You've made a standing argument here, and obviously when justiciability concerns are raised, that's a major red flag in any case. We have here, though, the legislature seems to have authorized any citizen to be able to bring suit for an open meetings violation. Doesn't that, in and of itself, address your standing concern in this case? The legislature's conferred a right on every citizen in Tennessee to be able to, and you're making an argument, it's a generalized grievance, but legislature's created a statutory right, haven't they?
It satisfies the statutory standing requirement, Your Honor. Our argument assumes statutory standing is satisfied. Our argument is purely constitutional standing.
So your argument is the legislature can't confer a statutory right upon a citizen to bring a challenge to an Open Meetings Act violation?
I put it a little bit differently, that the legislature cannot override justiciability requirements that this court and the Tennessee Supreme Court have held as a matter of jurisprudence that are required, grounded in the separation of powers provisions.
That's a constitutional challenge to the statute itself, isn't it?
No, Your Honor. It's a case-by-case inquiry.
Well, if the legislature says you have a statutory right, every citizen in Tennessee, and you're saying the legislature can't confer a statutory right, that sounds to me like a constitutional challenge to the statute.
No, Your Honor. There are two different standing requirements. Statutory standing, the Tennessee Supreme Court at Norma Fay delineated between statutory standing, prudential standing, and constitutional standing. And the constitutional standing argument, the justiciability requirement that we're advocating here, is a separate inquiry. And when the courts undertake that inquiry, they don't look to see whether the statute itself is constitutional. Like the U.S. Supreme Court in Lujan addressed a very similar statute that authorized any citizen to bring an action.
In Council in Lujan, the court specified that Congress has latitude to create statutory rights. They went too far in Lujan in that they created a right that was essentially a good government right. But Congress and Justice Kennedy has a discussion in terms of the ability of Congress to have flexibility with creating rights. Here, the legislature said every citizen in Tennessee has a right with regard to open meetings, and I'm struggling to understand how this isn't a constitutional challenge to that statutory right that you're making. We have to invalidate the statute to reach the conclusion that there's no standing in this case.
Judge, I respectfully disagree. In Lujan, the court said yes, the Congress in that instance can provide a statutory cause of action, but that doesn't address the separate constitutional standing question, and that's what Lujan found was not satisfied by the plaintiff, that there was not a particularized injury among the group of citizens that the legislature had authorized to bring suit. There has to be an individualized harm by the plaintiff who is invoking jurisdiction of the court. And that's the same particularization requirement that the Tennessee Supreme Court in Darnell recognized, and justiciability cases thereafter in Hargett.
Do you have any Tennessee precedent applying that concept in the context of an open meetings challenge?
Not in Tennessee, Your Honor. The cases that have been decided in standing have address statutory standing, which is, again, generally the legislature's authority to recognize a general class of plaintiffs to bring a cause of action, not the separate constitutional standing, the particularization requirement that is a justiciability requirement beyond what the statutory scheme provides.
In terms, I raised the question with opposing counsel regarding mootness. I did not see, I'm going to go back and take another look at the reply brief, but I did not see a response on your mootness argument. What do we do if there is not a response in the reply brief when we're talking about justiciability issues that are being raised for the first time on appeal? How does waiver play into that type of argument?
We haven't found any authority in Tennessee appellate courts addressing the justiciability of the obligations of a court to address justiciability concerns expressly. Tennessee courts generally mirror federal law, and federal courts generally require courts to consider justiciability whether raised by the parties or not. So if you're asking me, I just don't have it.
Can you waive you've made the argument, if there's not a response, do we have a waiver in that circumstance is opposing counsel essentially conceding mootness if there's a failure to respond? And there may not be. I may have missed it in the brief. But is there an obligation to respond to your brief in this case on that point?
I honestly don't know if there's case law on that issue. I recall, in all candor with the court, the argument generally made that they're not seeking to invalidate the action that was undertaken at the alleged secret meeting, and that they were advancing declaratory and injunctive relief claims. And whether that's in their brief, they've certainly advanced that argument thus far. And I would point the court to Person, the Court of Appeals opinion in Person, that addressed that very issue in 2009, where the county commission rescinded a resolution creating a judgeship. The plaintiff said, we're not trying to redo this. We just want injunctive relief that don't violate the law again, and so we're not moot. And the Court of Appeals said that is not enough to ensure a live, ongoing dispute between the parties. So our position is that it is moot, whether they've waived the argument or not. Then ultimately, again, I think our central point is that even assuming this is a justiciable dispute, even if there had been a violation of the act, the commission cured that unquestionably just based on the transcript of the public meeting itself by giving everyone an opportunity to have a free exchange of ideas, giving plaintiffs' counsel an opportunity to talk, the citizens themselves an opportunity to talk, and under the Open Meetings Act, that's not a violation. The last thing I would point out is Mr. Roberts indicated that there's nothing in the record supporting the idea that Metro Legal was providing legal counsel to the commission. And I would just point the court to a couple of things. Charter provision 8.602, which provides that the Department of Law shall provide legal advice to boards and commissions.
Asking questions for opposing counsel, one of the questions I had was regarding the nature of the claim. The trial court didn't seem to address the portion of the claim that relates to the meeting going beyond any legal advice that was provided, or is there a portion of the trial court opinion you could point me to that addressed not the existence of the meeting itself or legal advice, but that essentially members started talking about policy after? And it seems to me that's part of the claim that's being made in this case. And I didn't see that addressed in the trial court's decision. I might have missed it. I might just be missing things today. But is there anything in the trial court's order where the trial court has addressed that portion of the claim?
Talking about the aspect of the substance of the meeting and what was going on?
It seems the claim wasn't just that there was this meeting. Certainly the claim was there was this secret meeting and they're not really lawyers for it, but also that the conversation started on policy after the legal advice had been given. May be true, may not be true, but it seemed to me that was part of the stated claim here, and I didn't see the trial court having addressed that in its decision.
I don't remember whether the judge directly addressed that question. I know there is a contemporaneous letter from the Metro Law Director refuting that idea, a letter that is attached to the complaint itself, making clear that the commission didn't make any decisions during the alleged private meetings or deliberate towards decisions.
Can we consider those facts in the context of the type of motion we're looking at here, a motion on the pleadings, or decision and a motion on the pleadings?
I think you can, Your Honor. It's a letter that the plaintiff attached themselves to the complaint, page 400 of the supplemental record. And that's a contemporaneous articulation, much like an affidavit would be, of this is what we talked about from an officer of the court, and confirming that there had not been any decisions made or any discussions deliberating towards the decisions. Also, if you look at the September 25th transcript of the public meeting, you can see there are references to the legal advice that was provided from Metro Legal in its capacity as a lawyer for boards and commissions. And ultimately, Your Honor, even if I'm wrong on all that, even if I'm wrong on the justiciability point, wrong on the meetings point, we get down to cure. And Mr. Roberts hadn't offered any legal basis not to find cure here as an alternative ground to affirm on which the Chancellor properly granted Rule 12 judgment on the pleadings. We ask that the court either dismiss the appeal for lack of justiciability or affirm on the merits.
All right, thank you, Mr. Sauer. Mr. Roberts, you've got 3 minutes.
Your Honor, 2 final points, if I could, addressing your question and the appellant's statement. Metro Charter requires that the Metro government provide legal counsel for the Election Commission, not be the legal. And in fact, the Election Commission had its own attorney for many years. Lionel Barrett was there, that Metro paid for. And as evidenced by today, they're not from Metro Legal. They are a private law firm being paid by Metro government to represent the commission. There is nothing ever, and there's never been a history of Metro Legal automatically. And I would submit to you that if Metro Legal was to represent them in a matter and not sue them, as Chairman Delinas talks about, that they would you would have a meeting and they would say, we're going to meet with our counsel, Metro Legal, and they would go into that executive session. There is no proof whatsoever in this record that at the time that meeting was held, that Metro Legal represented the Election Commission. And that's just the truth. The second thing you brought up, Your Honor, was about the cure. And I'm fully aware of the cure. I recognize the fact that a board might have to meet on an emergency basis or might inadvertently meet, and there's steps they could take to cure it. I disagree with opposing counsel. If you read that transcript, there's not one mention of what happened prior to September 25th. Many people came and spoke. Many comments were made about what those people said. There was much discussion. I don't disagree with that. But what there wasn't was any effort, no one iota of effort to cure those prior meetings. They're never mentioned, they're never discussed, the legal advice is never discussed, the discussions are never discussed, nothing. It's almost as though they didn't happen, and that was intentional.
What would you point the court towards to suggest that that's required as part of cure? That that's required as part of cure, that they have to talk about what happened before. They have to discuss the earlier meetings. What authority would you point the court towards?
Well, I would say that there has to be that. That's the cure. That is the public recognition that the board acted outside of the law, but using the safe harbor, is coming back and saying, hey, we had this meeting, we're going to discuss this publicly, as we're supposed to do, as we're required to do. That's how you cure it. And
So
the
you're saying
transcripts don't support that.
acknowledgement is an essential component, essentially, of cure. And acknowledgement is an essential component of cure.
Yeah,
They have to acknowledge what happened previously to cure the prior violation.
I think they would have to, Your Honor. They would have to acknowledge what happened, have some discussion. And I submit to you, the only iota of information we have about what happened those prior two meetings was Chairman Delaney's statement. It's in our reply brief, where he says, well, Metro may not represent us in some future litigation because they may be suing us. And that one phrase caught me completely when I read it and said, where did Chairman Delaney get the idea that he was going to get sued? And that is the only reference to what happened beforehand. We're not asking for the world, Your Honor, if I can finish. We just want the government's business conducted in public as the law requires, with the constitutional protections of attorney-client privilege, but open and transparent. I don't feel like we're asking for too much, and we'd appreciate a reversal. Thank you.
Thank you, Mr. Roberts and Mr. Sauer, for your arguments. We'll take the matter under advisement, and that concludes the docket.